Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys, with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. For the next half hour, we have a panel of experts assembled ready to take your calls and deal with a subject matter that we believe will be of interest to you tonight. Before we get into what we're going to talk about tonight, let me give you kind of the lay of the land. If you're new to the show, all throughout the program, you'll see ways you can join our conversation, ways that you can get your questions to us. We'd love hearing from you. That's the best way for this next half hour to go. Also, a neat thing that Hollis Wright does, and they make available each and every Sunday night, is attorneys are standing by live right now to take your calls. So if you'll pick up the phone and give them a call if you have a question, opportunity there to get some great free legal advice. From the firm of Hollis Wright, Carter Clay is leading our conversation tonight. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing very well, thank you.
Yeah, tonight we're going to be talking about bankruptcy. Unfortunately, there are a lot of people that are out there struggling financially, struggling to keep up and make ends meet in terms of the income that they're generating from their employment to meet the debt obligations that they have, whether it be credit card debt, mortgages, and all kinds of other debt. And so
Right.
Bankruptcy is, like I said, an unfortunate part of the lives that we all have. It's something that everybody should be aware of in case they get in a situation where the debt becomes so overwhelming that they don't have anywhere else to turn but to an attorney to pursue a bankruptcy on their behalf. And so there are thousands and thousands of people that are out there right now struggling financially and may ultimately be susceptible to having to go through the bankruptcy process. One of the reasons, although there are many reasons why people have to file bankruptcy, one of the reasons that we tried to address with Obamacare or the Affordable Health Care Act is that a lot of people face bankruptcy due to medical bills that are incurred through an incident or an accident or a health condition that arises requiring significant medical treatment, and they're just inundated with medical bills, and it's something totally unexpected and really throws them off balance from a financial situation, and they really have to go through the bankruptcy court system from that standpoint. We're very fortunate tonight to have Stephen Jones here with us. He is a practicing attorney here in the Birmingham, Bessemer area. He's been handling bankruptcy for many years now, and wanted to have him on the show to share his insight and knowledge and kind of explain to the viewers the different types of bankruptcies that may be available to them, and kind of walk us through the process if you have to file for bankruptcy. So Stephen, thank you so much for being on the show.
Well, thank you for having me.
And tell us a little bit about you personally, your background professionally, and how you got involved in handling bankruptcies.
I've been an attorney about 25 years and have a general practice and do a lot of divorces and other things like that. But I do bankruptcies. I started doing a lot of those about 10 or 12 years ago when the economy got tough. And it's surprisingly a pretty good way to fix your credit and get yourself out of a lot of holes that you know, the economy or a car accident or any other kind of medical bills have gotten you into.
Yeah, now, so there are several different types of bankruptcies. I mean, businesses can file bankruptcies, individuals can file bankruptcies, and I believe businesses are handled under, I believe, the Chapter 11 code, and individuals have the option of availing themselves to potentially a Chapter 13 or Chapter 7 bankruptcy. And we're not going to be talking about business bankruptcies tonight. That's saved for another night. What we're going to be focusing on tonight are the options that individuals have in terms of bankruptcy, correct?
Yes.
And what are those options? And when we talk about Chapter 13 and Chapter 7, that means something to you and me, but to non-lawyers or lay people out there, explain where those chapters come from and what we're talking about.
Well, those are simply chapters in the bankruptcy code.
Okay.
And there are two different kinds that are generally used for consumers. And that's a Chapter 7 or a Chapter 13. A Chapter 7 is considered a straight bankruptcy. And that's where you basically put all your debts in one basket and they're gone. You can actually keep your car and keep your house, you just have to keep paying for them. Chapter 13 is a little different. You have to keep paying your bills. A lot of people don't qualify now for a Chapter 7, so they have to file a Chapter 13, and they can still keep their car and house, they just have to pay for it. And they generally have to pay some percentage of their unsecured debts.
Okay, now is Chapter 13 what lawyers refer to as debtor's court?
Yes.
Okay. And so as I understand it, Chapter 13 is the process whereby you can go before a bankruptcy court, you can inform the bankruptcy court through the disclosures about what your debt responsibilities look like and who the creditors are and those types of things. And do they come up with a payment plan or a schedule for the debtor?
Yes, that's right. You actually present a schedule to the court and say, I'd like to put what I'm behind in my mortgage in bankruptcy court, and my car payment, and my unsecured debts, my credit cards, medical bills, things like that. And you can also reduce your interest rates that you're paying on your cars and credit cards. A lot of times people get in trouble. Maybe their wife will lose their job, or the husband will go from working at U.S. Steel making 60 hours a week to 32 hours a week. So now they were cranking along with 2 cars and a house and a bunch of credit cards, and now they can't pay anything. So the credit card bills jack the interest rate up to 28%. If you put that in debtor's court, it's at 0%. The car payment might be at a high interest rate, and you can lower that too.
Can you negotiate on the principal debt in Chapter 13? In other words, if you owe $100 to a creditor and you file for Chapter 13, can you go into the Chapter 13 bankruptcy court, and part of that process, can you say, well, I don't have enough funds to pay you dollar for dollar, but hey, I can work out a schedule to pay you $75 of the $100 if that will release me?
That's called a composition case, and it's kind of a combination between bankruptcy and debtor's court. You generally have to pay all your car payment and all of your house payment that you're behind, and continue to pay your house payment. But what you're referring to is like the unsecured debt, the credit cards, medical bills. You can pay 75 cents on the dollar or 10 cents on the dollar. Just depends on what you can afford. Generally, the credit card companies and the medical bills that are owed, they don't argue about it. They're just glad to get some money.
Yeah, sure. Now, briefly explain the difference between secured debt and unsecured debt.
Secured debt would be like your house and your car, motorcycle, boats, things like that. Of course, it's hard to keep a boat. The judge generally is not going to let you keep a boat and a number of cars if you've got a bunch of unsecured debts that you're not going to pay. Right. I mean, you're trying to make ends meet. It doesn't make much sense to continue to have a boat and 4 cars.
Yeah, so like if you've got cars or a house with a mortgage on it, that mortgage or a car is secured by that collateral. So in other words, when you go and buy a car, if you finance the car for $10,000, the collateral will be that car. So if you default on your payment, they can come and repossess the car.
That's right, and that's the easiest thing to get repossessed is a car. It's a lot harder to lose your house. And the credit card companies are the ones that'll call and just raise Cain with you, but it's harder for them to get any money.
Yeah. Now what happens if you don't meet your obligations of the payment plan that is set up through the Chapter 13 bankruptcy?
The judges around here will give you a chance. If you have some problem, your transmission goes out or something, they'll bring you back to court and say, hey, you missed a couple of payments. It's going to go up a little bit. Can you afford this? And generally you keep trying.
A couple of questions we've got, as you might expect, a lot of really relevant questions here. If I file for bankruptcy, will my creditors stop harassing me?
Absolutely. In fact, by law, they have to.
Okay.
Now why is that? Is that what we refer to as the automatic stay?
Yes. They have to
that a little bit.
Quit harassing you. Consumer Protection Clause is what it's called. And basically, by law, they have to quit bothering you, quit calling you. They have to wait for the court to approve a plan to get paid. That is if it's a Chapter 13.
All right, time for our first break. So let's just pause it right here. Really some interesting stuff talking about bankruptcy. We'd love to have you join our conversation. There you see how you can do so. A reminder, you can find the firm on social media as well. Search Hollis Wright to find them on Facebook and also Twitter. It's Hollis_Wright. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, You can call, email, or text us, or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into the attorneys. A reminder, attorneys are standing by live right now to speak with you. So maybe if you're thinking, hey, I could sure use some free legal advice, got a question, don't know where to turn, you could turn to the attorneys of Hollis Wright. Just pick up the phone and give them a call. Now they're going to be available all through the program tonight. Carter?
Yeah, Stephen, I want to shift gears and talk more specifically about the Chapter 7 bankruptcy process. We've been focused primarily on the Chapter 13 process up until this point, but before we talk about Chapter 7, explain a little bit about who is or is not eligible for the Chapter 13 process.
All consumers are eligible for it. Okay. Now you have to do what it's called a means test, and it's your means, your ability to pay your bills, and basically they stick it in a formula, and you can either apply, you can either do Chapter 13 or you can do bankruptcy. Okay. Which is Chapter 7.
Chapter 7. So in other words, one of the factors or criteria that the court will look at is if you tried to go into Chapter 13 bankruptcy process, but you don't have a job and you don't have any income, that may not be a route that is available to you.
Yes, you'd have to be in debtor's court, you have to have a job. Yeah, that's Chapter 13. To file bankruptcy, you can have a job or not have a job, and that's Chapter 7.
All right, and when you say bankruptcy, you're speaking in the Chapter 7 context.
I really am, yeah. Okay. That's what you're doing there. And when you do a Chapter 7, you don't get to negotiate too much on your car or house payment. In fact, you kind of have to be caught up on both of those to keep your car and house. But your unsecured debts, medical bills, things like that, just wash away. It's like an Etch-a-Sketch.
Yeah, and as I understand kind of the Chapter 7, what I've always heard it to be is it's a total liquidation bankruptcy. Essentially where you go in and you disclose all of your assets to the court, and I guess the court decides, or maybe the law has already set forth what you can keep and what you can't keep, and then they sell off a bunch of your assets to pay off your debt.
That sounds really scary, but they really don't come in and sell off your stuff. You can keep a certain amount, $7,500 worth of value of your personal property that's paid for. Okay. And we're not talking about brand new value, we're talking about as is value. We're not talking yard sale value either. Okay. You can keep your car if you want to, but you've got to keep making the payment for it at the original terms of the contract. It's very rare where you can negotiate that. Or you can let your car go, and people say, well, won't they sue me after they sell it? Well, they will if you don't file bankruptcy. You file bankruptcy, you're out of it.
Well, in terms of the property that you can't keep as part of the Chapter 7 process, they ultimately, I guess, attempt to sell that property to get cash so that you can pay off your debts?
The trustee might take some of that property that's paid for. You rarely see that happen, though. Okay. The mortgage company might take your house, then it's out of it, or the car company might take your car. Okay. But generally, you rarely file a bankruptcy, Chapter 7, when you know your client's going to lose a bunch of stuff. If they've got paid for things, then you kind of have to file a 13. Okay. And then they have to pay back to avoid losing anything.
So I guess ultimately, let's say somebody's out there with credit card debt, $40,000, $50,000 in credit card debt, and that's one of the creditors that is disclosed to the bankruptcy court. Mm-hmm. Let's say they filed a Chapter 7. How does that credit card company get paid through the bankruptcy process?
If it's a Chapter 7, they don't. They don't get anything. Okay. For example, let's say you have $50,000 equity in your house. Okay. You couldn't do a bankruptcy because you'd probably lose your house. Okay. You'd have to do a debtor's court and pay back the credit cards. If you don't have any equity in your house, you can keep your house, keep making your house payments. Okay. Most cars don't have equity in them. You can keep your cars, keep making car payments, wash away the unsecured debt.
All right. And so is there certain debt in a Chapter 7 bankruptcy that is not dischargeable through the bankruptcy court?
Now there is student loans, court fines and fees you owe, things like that, you cannot get out of it. Income taxes, you can't get out of that.
And so most people call Chapter 7 a fresh start.
That's right.
You're basically putting all your debts on the court, and you're saying, I can't meet these debt obligations, and the court is wiping the slates clean, and you're getting a fresh start to where you can start anew.
That's correct.
A couple of questions we've got here. Will bankruptcy affect my spouse?
It will if they file with you. If they don't file with you, it will not affect your spouse. Used to years ago, before everything got very computerized, sometimes it would creep over into their credit report and you'd have to fix it. More often than times not, it affects, maybe if you're a junior, it can hit your dad's credit by mistake.
Right.
But now everything is based on your social security number, so it's not really a problem. It's not going to affect your spouse.
All right. Another question we got, if I file for bankruptcy, will I ever get credit again?
Yes. If you file for bankruptcy, you can really start building your credit back right away.
Really?
If you have a job, I mean, think about it. You have a job, you're making your car payment still, you're making your house payment still. In 2 or 3 months, you've been making your car payment and your house payment, and you've got a full-time job, you can get credit pretty quickly.
Yeah. Well, that's good. In terms of the spouses, is that something that you evaluate in your practice? You've got a married couple that will come to see you. Do you kind of discern whether you need to file it jointly for both of them or whether you can file it for one and sort of insulate the other? Is that part of your practice?
We do that all the time. If one spouse has very little debt, you just leave him or her out, and then they can, keep going if they need to.
Yeah, now one of the things that I've experienced in my practice is that we have personal injury practice, and we'll represent individuals that have been injured in accidents, and we always tell them, look, we know you're financially struggling because of your injury. If you file bankruptcy, let us know, because you may have to disclose this lawsuit or claim to the bankruptcy court, because the bankruptcy court will consider that an asset. Is that true?
Yes, you not only should disclose it, you have to, or it could destroy your lawsuit. You could have your case dismissed on your end of it.
Absolutely.
Time to step aside. This is our final break of the evening, so we'll take a quick break before we come right back. A reminder, love to have you join our conversation. Ways right there to get in touch with us. Always enjoy getting those questions from you. Also, those attorneys are standing by live right now, so pick up the phone and give them a call. Just a few minutes remaining there. Stay tuned. We've got more of the attorneys coming right up.
I'm Tyler Vail with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this. The parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the Attorneys, talking about bankruptcy. Would love to have you join our conversation. Also, attorneys standing by live from the firm of Hollis Wright right now to take your call. Continuing our conversation here, a question we've got: can my boss fire me for filing for bankruptcy?
Well, legally, they're not supposed to.
Right.
Can happen sometimes, and you might have a right to sue them, but no, they're not supposed to be able to fire you for filing bankruptcy.
Well, what would be the reasons that an employer would fire somebody for filing a bankruptcy, though?
I guess if you implied or provided documentation that said you didn't have any credit problems and you worked for a bank or something like that.
So maybe it was just a credibility issue at that point?
Yeah, and then you file bankruptcy and they, for some reason, were under the impression given by you that you had good credit and you weren't a credit risk. Maybe.
Along those same lines, can creditors who are trying to collect on a debt, can they call your employer or call you at your place of employment to try and collect a debt there and inform your employer of your debt obligations and your failure to pay?
Again, they're not supposed to.
Okay.
They can call any number you put on your credit application, but you can tell them not to call my work, not to call my employer, etc. A lot of times they still do, and that might be a cause of action in a civil matter.
Yeah, I think, does that fall under the Fair Debt Collection
Yes.
Practices Act, which is a federal code that sort of prohibits that type of conduct?
That's exactly right.
Yeah. Well, I certainly hope that there aren't repeat filers out here, but one of I'm certainly there probably are. One of the questions that we have is, if somebody files for a Chapter 7 bankruptcy, can they file again at some later point in life?
They can. After 8 years, they can file a straight Chapter 7 bankruptcy. Now, they can file a debtor's court petition within just a few months after a bankruptcy. I mean, there really isn't a reason to. But 2 years down the road, let's say you get in a pinch again, you can't file bankruptcy, Chapter 7, but you can file debtor's court, Chapter 13.
Okay. Let's talk a minute about what an individual can expect that files a Chapter 7, and then also individuals that are filing a Chapter 13. What can they expect in terms of the process that they're going to experience and the timing of that process?
That's one of the first questions I'm asked all the time. And you're just surprised how easy filing, frankly, Chapter 7 bankruptcy is. You talk to the lawyer, you provide him with all the information, that being your pay stubs, tax returns, you run a credit report, you have one hearing before a bankruptcy trustee, he reviews everything, the creditors are given an opportunity to show up, they rarely do, and in a couple of months, that's it for a Chapter 7 bankruptcy, and you're discharged from all your debts, unless it's something you wanted to keep.
And so you really only have to attend one hearing through the Chapter 7 process?
One hearing, swear that you're going to tell the truth, and it takes literally about 15 seconds.
Okay, wow. And
It's
then
really quick. It's nothing to it.
How is the Chapter 13 process different?
Chapter 13, you're under the scrutiny of the court for anywhere from 3 years while you pay your bills back, or even up to 5 years. So it's a little different, but you go to 2 hearings. You go to see another Chapter 13 trustee, and then you go see the judge. And if you've been doing what you're supposed to over a couple of months, that's the last time you go to court. You just keep making your payments. A lot of people have it cut out of their check. So before, when they were paying 15 credit cards, 2 cars, and a mortgage payment, now they're having it cut out of their check and they never see it.
Yeah. I think you mentioned earlier in the Chapter 13 context, I asked you about, well, what happens once a payment plan is established, and let's say they're a year and a half into complying with the plan, and all of a sudden they just stop paying pursuant to the plan. I think you mentioned that judges will typically try and give you a second chance and work that out. But what happens if they don't comply and the person that filed for Chapter 13 just stops payment?
If they stop payment and they just quit, the trustee will file a motion with the court, and you will have a hearing, maybe 2 or 3 months of not making payments. If you have a good reason, I got hurt at work, one of the spouses lost their job, somebody had a baby, anything like that, that's a good excuse. And the judge will rework it, and if you were paying $200 a month, well, it'll go up to $230 a month. But if you just decided, I don't want to pay this anymore, well, guess what? Once you stop and it's dismissed, all the creditors going to come back raining on you.
Well, and that was ultimately going to be my point, is if it gets dismissed, then the creditors who may have given up a little bit in terms of getting all of the debt paid back, they're not
they're out from under that original agreement through the bankruptcy process, and they're free to then go after you dollar for dollar for the debt.
The phone starts ringing and the letters start coming. That's right.
Okay.
Something that you see a lot, you see a lot of ads for credit counseling agencies, the bureaus, and all that sort of deal, and they make these wild promises, you know. What is your thought there, and is there any credibility to those kind of groups?
I think there's a lot of people who can use those kinds of services, but I think they're a total waste of time and money. They're not. All they're going to do is take your money and bank it up and take some of it and wait for the creditors. It's going to ruin your credit for 6 months to 2 years before anything happens. And frankly, you can negotiate that yourself if you've got the guts to do that.
Yeah.
You know, the easiest thing to do to get everything off your back is to file debtor's court or bankruptcy.
Right, yeah. All right, just a couple of minutes remaining, so just time enough for both of you. Just a final thought from you, and if you would, just go first. Just a final thought and a tip maybe for our viewers out there tonight.
Bankruptcy, it sounds terrible. You've heard stories, you know, you'll lose your house, you'll lose your car, you'll lose everything. But basically, you really just lose the weight on your shoulders. If you have a job and you want to file bankruptcy, debtor's court rather, and you want to keep your cars and your house, you can. If you want to, and all your other debts go away. If you're paying, you know, an elaborate, crazy interest rate on your cars, you can lower that down to 5% interest rate. So you can see right there that can save you a lot of money. If you don't qualify for a bankruptcy and you have to file debtor's court, that's the way to go. If you file bankruptcy Chapter 7, you can still keep your car and your house. All the other stuff washes away. You're still stuck with taxes you might owe or student loans, and in that case, you would probably want to do a Chapter 13. But if you do a bankruptcy, you're still going to have the same obligations on your cars and houses and get to keep it. So it's it really is a good way to get a lot of weight off your shoulders and keep going on with your life.
And I would just add to that, I think there's always been a lot of misinformation and misunderstanding out there in the general public that if you file bankruptcy, you'll never be able to buy a house again, or you'll never be able to get a credit card again. And as Stephen indicated earlier, that's just not the case. At least it's not the case as of this point in time in our society. You certainly can get a credit card. You certainly will have the ability to buy the house. It may be a little more challenging and difficult, but you certainly will have that ability. And quite frankly, I think people need to understand that if they're contemplating or even thinking about bankruptcy, they can certainly call and talk to somebody like Stephen, and they're not obligated to actually filing it. They can just get information and see what their options are.
Good stuff tonight. Stephen, Carter, appreciate the time.
Enjoyed it.
Thank you very much. Some great information tonight. Hope it was helpful to you. We appreciate you being with us as always. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.